The presentation is on the redressal of unknown grievances of the policyholder. We have seen in the panel discussion that every insurance was claiming that they are good and they are settling the claim at the earliest, and the broker is responsible for the underwriting as well as for the at the time of claim. Now I'll show you some incidents where the insurer is failing in his duty. Policy document, terms and conditions, everything is issued by the insurer, but at the time of claim, they are not following the terms and conditions what they have specified in the policy. Issue, whenever there's a mishappening, there will be claim. And there are some incidents, as I told you, the insurance company at the time of claim, mishappening, they are not following the terms and conditions. Grievance number 1, vehicle insurance. Mishappening of the is the theft of vehicle. Terms and conditions says, condition number 1, fourth line, it says, in case of theft or the criminal act which may be subject to the claim, under this policy, the insured shall give the immediate notice to the police and cooperate with the company in securing the conviction of the offenders. If you read the condition, that is the intimation to the police. But every time, whenever there is a theft, it may be the surveyor or insurer, they ask you file an FIR. Their condition says it is to be intimation to the police why the insurance company insisting for the FIR. And lots of claim, every claim is rejected by the insurance company in case it is not filed by the FIR is not filed. Though it is not a condition, but why they are asking for the FIR? Regulation, protection of policy or interest, regulation 11 says, whenever there is a claim for the protection of policyholder interest, everything should be defined in the policy, what the policyholder has to do at the time of claim. And it means the policy says it is to be only the intimations to be given why the insurance company is asking or surveyor is asking for the FIR. In one of the case, Oriental Insurance Workee Satnam Singh, in the October 2018 itself, it was shown that in case there is the Oriental Insurance rejected the claim, but if National Commission said no, once the policyholder has given the intimation to the police, claim is payable. It is, the FIR may or may not be filed, the claim is to be paid. It is said in the October 2018, this judgment of National Commission, Oriental Insurance Workee Satnam Singh. Similarly, the burglary policy. Again, the theft is taking place. And condition says, and the burglary, you go through the policy document, it says, in writing to the nearest office of the insurance company and lodge a complaint with the police. Again, the surveyor is insisting to go for the FIR. Why it is so? Different insurance companies, they are giving the different wording in the policy document. IFCO Tokyo lodges a complaint to the police. Reliance Industries inform the police and get the FIR. Oriental Insurance, intimation to the police. United India lodges a complaint with police. Future Generally lodges a complaint to the police. Nature Insurance lodges a complaint notice. Only the intimation of lodges a complaint. Nowhere it is mentioned the FIR is to be filed. But claim is not paid unless until the FIR is filed by the policyholder. Once the FIR is filed, so many sections are applicable under IPC, and the claim is not paid by the insurance company, which is again this is the grievance of a policyholder. Engine protection cover. Every insurance company has given the add-on cover. The issue is why it is add-on cover. Because in one of the judgment, Bharti AXA versus CM Goyal in 2015, they say engine protection is covered on the flood and inundation. It is a wider coverage, so this is engine protection is the specific exclusion. It should be mentioned in the policy. Nowhere it is mentioned in the policy, so it will not be excluded. It is covered under the basic policy, not in the add-on cover. There are so many judgments. Bharti AXA versus Bhopal Ombudsman, Majid Singh Khera, G. Sridhar, Mr. Anand, these are the judgments issued by the various forums. It is the National Commission, District Forum, and the State Commission, where it is said it is payable under the basic policy, no need to take the add-on cover. Personal accident. Do you know that in the policy personal accident, the heat wave or the sunstroke and the cold wave is covered under the personal accident policy? The judgment of National Insurance Company versus Rita Devi, where it is clearly said, it may be the cold wave, it may be the heat, sunstroke, it is covered under the personal accident policy. Their judgment is based on the Supreme Court of the USA. If you go through that judgment, they have very clearly defined what is the external accidental means. They say both these will be covered. It may be the heat, that sunstroke or the cold wave. Thousands of people are dying in India. The poor people, they are dying due to either the sunstroke in the say Bihar or Odisha and the cold wave in the northern region, but no claim is paid under Pradhan Mantri Bima Yojana. That all the poor people are registered with they are having the policy for 2 lakh rupees, but nobody is coming forward to pay the claim for these people, poor people. I requested to Chairman IRDA in the morning that such issue should be taken and the claim should be paid to the poor people when they are paying the premium for that. Health insurance. Now, one of the conditions in the most of the policy is the reasonable and customary charges payable. What is the reasonable customary charges? Nobody knows. A person has taken the treatment at Ludhiana in Punjab. For the bill was about 3.5 lakhs. And the TP has rejected the claim that he has reduced the amount to 2.5 lakhs. He says the same treatment you have taken in some other hospital, which is located at 100 miles away, that in Chandigarh, which is the distance between Chandigarh and Ludhiana is 100 kilometers. He said, in case you have taken the treatment at Chandigarh, the expenses would have been 2.5 lakhs. That's why it is a reasonable charges and will pay only 2.5 lakhs. So this is the interpretation of the reasonable and customary charges. If you see the regulation, health regulation, it clearly states that all insurance will design a policy in such a fashion there should not be any restriction. There should not be any restriction to take the treatment in any hospital. But by putting this reasonable customary clause, it has put the restriction for the policyholder to take the treatment. He has to search in which hospital he will get the lower rate, so he should admit in that hospital, which is contrary to the basic condition of the health insurance. Fire insurance. We have seen the access has been increased by all the insurance companies with effect from 1st April 2011. Everyone is, whenever there is a claim, and the insurer is deducting that excess, whatever the excess is defined in the revised excess has been defined. The IRDA issued a circular in 2006 that only the policy wordings remain the same and de-tariffing is only the premium. Only the premium can be de-tariffed, not the policy wording. When the policy wording cannot be changed, only the premium is allowed, so why the excess has been increased? Because excess is part of the terms and condition. Exclusion has the first exclusion is the excess. It means that excess cannot be increased without the approval of the IRDA. If you see the policy wording of new general insurance company, Kotak General Insurance Company on the website of the IRDA, because IRDA website, all the products approved by the IRDA, the terms and conditions they are putting on their website. If you see the policy wording of the fire insurance, the Kotak General Insurance Company, they have written the clearly excess is approved 5%, minimum 10,000, of the old excess 5% of the minimum 10,000 in case of AOG peril, and the rest of the cases at 10,000. But all insurance, the Kotak General Insurance, they are issuing the policy with the higher excess. It is again the contrary to the approval of the IRD. So these are the 6 unknown grievances with the insurers, because I have seen the most of the CEOs have already gone. Earlier in the panel, they were discussing everything they were blaming to the broker. That broker is not taking care of at the time of placing the business. They are not taking at the time of claim, at the time of claim. But the policy documents, terms and conditions have been defined by the insurer, not by the broker. But at least at the time of claim, they should honor their own wording so that the claim can be paid easily and without any problem to the policyholders. Thank you very much.